Trump in freefall. Melania's unexpected alliance with prosecutors shocks the nation. Not a leak, not a rumor, not an unnamed source. This morning at 9:52 a.m., a formal cooperation agreement between Melania Trump's independent legal counsel and the federal prosecutorial team was filed directly into the public docket of the federal civil fraud case. 7 pages, signed by both parties. Exhibit A attached. Exhibit A is a 23-page summary of the evidence Melania has agreed to provide. The summary is sealed. It is publicly accessible. And it describes categories of evidence that Trump's legal team has spent 17 months swearing did not exist. Trump's lead attorney was notified through the docket at 10:07 a.m. by 10:44 a.m. 3 emergency motions had been filed, all 3 denied before noon. By 1:30 p.m., the White House counsel's office had received 4 calls from Trump's personal legal team. None returned. By 3:15 p.m., 2 of Trump's longest-serving defense attorneys had formally withdrawn from the case. By 4:47 p.m., Melania's independent counsel held a brief press availability outside the courthouse and said 6 words: she is cooperating fully and completely. 5 days. 11 major developments. Here is exactly where things stand. A formal signed cooperation agreement between Melania's counsel and federal prosecutors is now public record. Exhibit A describes 23 pages of evidence categories that directly contradict 17 months of sworn defense filings. 3 emergency motions filed and denied within 90 minutes. 2 senior defense attorneys withdrew same afternoon, White House counsel not returning calls. Melania's lead attorney confirmed full cooperation in 6 words on courthouse steps. The judge issued a standing order at 5:33 p.m., accelerating the case schedule by 60 days, and at 6:14 p.m., Melania's counsel filed a supplemental notice indicating the first evidence tranche would be delivered to prosecutors by Friday. Today did not damage Trump's legal defense. Today replaced it with something the defense has no architecture to respond to. A formal cooperation agreement is not a threat. It is not a development to be managed. It is a signed document that converts the former president's spouse from a background figure into an active participant in the prosecution of the federal case against him. There is no motion that reverses a signed cooperation agreement already filed on the public docket. There is no appeal that reaches a document both parties have already signed. And there is no legal strategy built over 17 months that accounts for the morning the cooperation agreement lands in public view before the defense team has finished their coffee. Most coverage is treating this as a political earthquake. It is not. It is a legal architecture event. I am going to show you exactly how a formal cooperation agreement changes the structural foundation of 3 simultaneous legal tracks, what the 23 pages of Exhibit A mean for every sworn affidavit filed in this case, and what the next 7 days look like from inside the case timeline. 3 tracks, all moving, all accelerating. Stay with me. Trump, 3 emergency motions denied before noon, 2 senior defense attorneys withdrawn, White House counsel not returning calls. No public statement on the cooperation agreement's substance. 17 months of sworn affidavits now directly contradicted by a signed cooperation agreement whose Exhibit A describes the evidence that was sworn not to exist. Defense team structurally compromised with 2 senior attorneys gone and no replacement counsel yet identified. Melania, formal cooperation agreement signed and publicly filed. Exhibit A attached and publicly accessible. First evidence tranche delivery confirmed for Friday. 6 words on courthouse steps. She is cooperating fully and completely. Has not appeared personally. Her attorneys are speaking for her with precision and her absence is deliberate. Federal prosecutors, formal cooperation agreement in hand. Exhibit A accepted. First evidence tranche arriving Friday. Case schedule accelerated 60 days by judicial standing order. Operating with complete information while defense operates with 2 fewer attorneys and no knowledge of what Friday's tranche contains. Active proceedings. Federal civil fraud case, primary track. Formal cooperation agreement, public record. Exhibit A describing 23 pages of evidence categories publicly accessible. Case schedule accelerated 60 days. First evidence tranche Friday spousal cooperation track. Agreement signed, Exhibit A filed. Friday tranche confirmed. Full cooperation underway, not pending. Congressional oversight track. 6 committee chairs issued statements within 2 hours of the docket filing. Senate Judiciary and House Oversight both announced accelerated inquiry timelines citing the public cooperation agreement. Immediate pressure points. Trump's defense team is structurally compromised. 2 senior attorneys gone with no replacements identified, and a 60-day accelerated schedule now in effect. The case moves faster than the defense can rebuild. Exhibit A is publicly accessible, meaning prosecutors, Congress, and the public all know what evidence categories Melania has agreed to provide before that evidence has even been delivered. Trump's remaining attorneys must prepare responses to evidence they have not yet seen described in categories they spent 17 months swearing did not exist. Friday's first evidence tranche arrives before the defense has even stabilized its team composition. That is the snapshot. Subscribe now. A formal signed cooperation agreement between Melania Trump and federal prosecutors is on the public docket this morning. Exhibit A is 23 pages of evidence categories. 2 defense attorneys are gone. The case schedule just accelerated 60 days. Friday's first evidence tranche lands before the defense team has even replaced the attorneys who walked out this afternoon. This is moving faster than any coverage can track. Hit subscribe. Every development from here breaks here first. The moment Friday's tranche hits the docket, I drop the full breakdown immediately. 17 months ago, Trump's legal team began constructing what they believed was a durable defense architecture around a single evidentiary premise. The financial transactions at the federal civil fraud case were executed without the former president's direct personal involvement in the specific structural decisions prosecutors were examining. The premise was not circumstantial, it was certified. Attorneys signed sworn affidavits, filed them across multiple proceedings, built 17 months of legal strategy on the assumption that the evidentiary record they controlled was the evidentiary record that existed. The architecture had one structural vulnerability that 17 months of careful document management had successfully obscured. Melania Trump was present for conversations, meetings, and communications that never entered the formal evidentiary record. Not because they were privileged, not because they were irrelevant, but because no one had asked her directly and her legal position had been publicly characterized as aligned with the defense. That characterization served the defense for 17 months. Public statements of unity, spokesperson assurances, the assumption baked into every sworn affidavit that the most consequential private witness to Trump's internal communications was not a prosecutorial resource. A senior federal litigator noted 8 months ago in a public legal forum, in any complex fraud case, the most dangerous witness is not the one you subpoena. It is the one who decides voluntarily to walk through the door. Because that witness controls the timings, the scope, and the terms. And by the time you know they are walking through the door, it is usually already open. The door opened this morning at 9:52 a.m. when a 7-page cooperation agreement landed on the public docket with a 23-page exhibit attached. 17 months of defense architecture met the one variable it was never built to survive. Melania's independent counsel files a notice of formal cooperation discussions with federal prosecutors. The notice is a procedural document indicating that structured cooperation negotiations have begun between a witness's counsel and the prosecutorial team. It is different from informal contact. Formal cooperation discussions follow a specific legal framework that ends in either a signed agreement or a documented breakdown of negotiations. Trump's legal team files an immediate objection, arguing the notice itself constitutes prosecutorial overreach and that any formal cooperation discussions with Melania must be preceded by a comprehensive privilege review conducted with defense participation. Objection overruled Saturday afternoon. The judge's notation, respondent's objection to formal cooperation discussions denied. Privilege waiver previously confirmed. Defense participation in voluntary witness cooperation negotiations not required or appropriate. What most people missed. A notice of formal cooperation discussions is not the beginning of the process. It is the documentation that the process has already begun. By the time a counsel files the notice, the preliminary conversations have already happened, and both sides have determined that a formal framework is worth pursuing. Saturday's notice meant Melania's team and prosecutors had already decided they were moving toward a signed agreement. The filing was the announcement. The decision had already been made. Cooperation negotiations continue through the weekend, 2 docket entries Sunday. First, a notice of document exchange confirming materials were transferred between Melania's counsel and prosecutors as part of the cooperation framework. Second, a joint scheduling notice from both Melania's counsel and prosecutors indicating an agreement in principle had been reached and formal documentation was being finalized. Agreement in principle. On a Sunday. That phrase on the public docket Sunday afternoon told anyone reading it that the signed agreement was not a question of whether but when. Trump's legal team files an emergency motion Sunday evening requesting the court compel a 48-hour pause in cooperation negotiations to allow the defense to file a comprehensive brief on the implications for the privilege log and existing sworn affidavits. Denied Sunday at 8:17 p.m., the judge's notation, emergency motion for negotiation pause denied. Voluntary cooperation between independent witness counsel and prosecutors is not subject to defense timeline management. New voices enter. Legal commentators who had been treating the cooperation discussions as a developing story began Sunday evening revising their assessments. Agreement in principle followed by a denied pause motion meant the agreement was landing Monday morning at the latest. Congressional staff monitoring the docket begin preparing for a public filing. 3 major legal publications update their case coverage Sunday night, noting the agreement is imminent. Final cooperation agreement terms are confirmed in a sealed filing at 7:44 a.m. The sealed filing contains the finalized agreement text before public filing. Both parties have signed. Exhibit A is attached. The court acknowledges receipt at 7:51 a.m. Trump's legal team does not know the agreement has been signed and sealed at 7:44 a.m. They file a preemptive motion Monday morning at 9:15 a.m., requesting that any cooperation agreement be subject to defense review before public filing. The motion is procedurally moot before it is filed. The agreement is already signed and in the court's possession. The judge denies the motion at 9:49 a.m. with a notation, motion denied as moot. Cooperation agreement executed and received by the court at 7:51 a.m. The defense filed a motion to review a document that had already been signed, sealed, and delivered to the court 74 minutes before the motion was submitted. That is the moment that captures the entire arc of the defense strategy across 5 days. They were responding to events that had already happened without their knowledge every single time. The court processes the cooperation agreement overnight. At 9:52 a.m. Tuesday, the agreement is unsealed and enters the public docket, 7 pages. Exhibit A, 23 pages of evidence categories, publicly accessible. Trump's lead attorney sees the docket update at 10:07 a.m., 3 emergency motions filed by 10:44 a.m., all 3 denied before noon. 2 senior defense attorneys withdraw by 3:15 p.m., White House counsel not returning calls. Judge issues 60-day schedule acceleration order at 5:33 p.m. Melania's counsel on courthouse steps at 4:47 p.m., 6 words. She is cooperating fully and completely. Supplemental notice filed at 6:14 p.m., first evidence tranche arriving Friday. The pattern. 5 days, a notice of formal cooperation discussions became a signed cessation agreement with a 23-page evidence exhibit, 3 denied emergency motions, 2 withdrawn defense attorneys, a 60-day case acceleration, and a Friday evidence delivery. Every defense procedural move across 5 days failed, and each failure accelerated the cooperation timeline rather than slowing it. Monday's procedurally moot motion set up everything that happened today with maximum impact. Here's the precise mechanism. By filing a motion Monday morning to review an agreement that had already been signed 74 minutes earlier, Trump's legal team created a public record demonstrating they had no knowledge of what was happening inside the cooperation process at any point across 5 days. The judge's notation that the motion was moot because the agreement was already executed and received made that knowledge gap explicit and permanent in the judicial record. Before yesterday, Trump's team could have argued they had been kept improperly uninformed of the cooperation process and that the agreement should be subject to challenge on that basis. After yesterday, the judge had explicitly ruled that defense non-participation in voluntary witness cooperation is not only appropriate but required. The motion designed to insert the defense into the process became the ruling that confirmed their exclusion was proper. Before yesterday, the cooperation agreement was signed but not yet public. There was a narrow window in which its existence was known only to the parties and the court. After yesterday, the judge's moot ruling put the fact of the agreement's execution on the public docket before the agreement itself was unsealed. By Monday afternoon, anyone reading the docket knew a signed agreement existed. Today's unsealing was confirmation of what Monday's moot ruling had already announced. Before yesterday, the defense had no public judicial record of having been excluded from the cooperation process. After yesterday, the exclusion was documented in a judicial notation that will be cited in every subsequent proceeding. Monday's procedurally moot motion gave the defense nothing and gave the record everything prosecutors needed going into today's unsealing. 7-page, 23-page exhibit, public docket. 3 specific changes that define the new legal landscape permanently. Before today, Melania's cooperation was a developing story with terms unknown and scope unconfirmed. After today, a signed 7-page agreement and a 23-page exhibit describing evidence categories are publicly accessible to prosecutors, Congress, the media, and Trump's legal team simultaneously. The cooperation is not a threat. It is a signed document with an attached evidence summary that is already public record. Before today, Trump's defense team consisted of the attorneys who had been managing the case for 17 months. After today, 2 of those attorneys have withdrawn. The case schedule has been accelerated 60 days, and the team must rebuild its composition while responding to an evidence tranche arriving Friday that they have never seen and cannot preview. Before today, the judicial timeline was set by standard case management procedures. After today, the judge's 60-day acceleration order means every deadline the defense was planning around has moved forward by 2 months. A defense team that just lost 2 senior attorneys now has 60 fewer days to respond to evidence from a cooperating witness whose 23-page exhibit summary describes categories of evidence the defense swore did not exist. The cumulative effect. 5 days ago, a notice of formal cooperation discussions was filed and an objection was overruled on a Saturday afternoon. 4 days ago, agreement in principle was reached on a Sunday and a pause motion was denied. 3 days ago, the agreement was signed and sealed at 7:44 a.m. and a defense motion filed 74 minutes later was denied as moot. Today, the agreement unsealed, 3 motions denied, 2 attorneys gone, case accelerated 60 days, Friday evidence tranche confirmed. Trump's legal team cannot reverse the cooperation agreement, cannot reseal Exhibit A, cannot slow a case schedule the judge just accelerated unilaterally, and cannot replace 2 withdrawn senior attorneys before Friday's evidence tranche lands. Like, if you are tracking every development as it happens, subscribe. Track 2 and Track 3 are where Exhibit A's 23 pages become the evidentiary foundation for everything that follows Friday. 2 defense attorneys are gone. The case is 60 days faster. And Friday's first evidence tranche arrives before the defense team has even identified replacements. The moment Friday's tranche hits the docket, I break every page immediately. Subscribe now. Track 1, the federal civil fraud case. Status, formal cooperation agreement, public record, Exhibit A publicly accessible, case schedule accelerated 60 days, first evidence tranche Friday, defense team structurally compromised with 2 attorneys withdrawn. Key date, Friday, May 23rd. First evidence tranche delivery. What happens? Prosecutors receive the first installment of the evidence described in Exhibit A's 23 pages. The tranche's contents will define the immediate evidentiary landscape of the case going into the first post-acceleration hearing. Trump's remaining defense attorneys will see the tranche contents for the first time Friday when they land on the docket. No preview, no advance notice. Direct docket delivery on an accelerated timeline with a depleted team. Track 2, the spousal cooperation track. Status, agreement signed, Exhibit A filed, full cooperation underway, Friday tranche confirmed, key date, Friday, May 23rd, first tranche delivery, and potential supplemental cooperation notice. What happens? Melania's counsel has indicated full and complete cooperation. Friday's tranche is the first installment of what Exhibit A describes across 23 pages of evidence categories. After Friday's delivery, prosecutors evaluate whether to request additional tranches on an accelerated schedule consistent with the judge's 60-day order. Melania's team is not delivering everything at once. They are delivering in tranches. That means every week following Friday is a potential new evidence delivery. The cooperation is not a single event. It is an ongoing process now formalized and accelerating. Track 3, the congressional oversight track. Status. 6 committee chairs issued statements within 2 hours of the unsealing. Senate, Judiciary, and House Oversight both announced accelerated inquiry timelines. Key date, Tuesday, May 27th. Both committees expected to issue formal document requests citing Exhibit A's publicly accessible evidence categories. What happens? Congress now has a publicly accessible 23-page evidence category summary that they can use to construct targeted document subpoenas. They do not need to guess what evidence exists, Exhibit A told them. Congressional subpoenas built around Exhibit A's categories create parallel discovery pressure on the same evidentiary territory prosecutors are pursuing through Melania's cooperation agreement. 2 institutions, same evidence map, operating simultaneously and independently,